Today's topic will discuss whether courts act fairly when constructive trust is imposed even if the parties never expressly intended to create a trust. In my opinion, courts can be fair in doing so. However, it's only fair when constructive trust is imposed according to principal limits. In Malaysian law, constructive trusts are important because it allows equity to prevent unconscionable retention of property, fraud, breach of fiduciary duty, and unjust enrichment. However, fairness becomes questionable if courts depend too broadly on vague ideas such as good consent without clearly explaining the legal basis for the trust. A constructive trust is different from an express trust. In express trust, the settler creates a trust intentionally and identifies the trust property, beneficiary, and duties. Meanwhile, constructive trust arises by operation of law. It is imposed by the court because it would be unconscionable for the legal owner to deny another person's equitable interest. This principle was explained in the case Paragon Finance against D.B. Takara and Co. Millet LG stated that a constructive trust arises when it would be unconscionable for the legal owner to claim full beneficial ownership over another person. This principle was used in Malaysian court in the federal court decision in Takako Sakao against Ng Pek Yuan case. This case adopted the Paragon Finance formulation. Article on Malaysian constructive trust by Tang Hang Wu and Yung Kai Liu also shows that Malaysian court depended heavily on unconscionability when developing constructive trust principles. There are two aspects to consider when analyzing the fairness of constructive trust. First aspect is that constructive trusts can be fair as they prevent a person from using legal title as an instrument of injustice. The second is constructive trusts can become unfair if judges have too much power to redistribute property without clear and predictable rules. Therefore, the main question is not just whether the parties intended to create a trust. The real question is whether it would be unconscionable for the defendant to keep the property without recognizing the claimant's equitable interest. The development of Malaysian law can be seen when the courts have accepted constructive trust as a flexible, equitable intention. In Tay Chiu Fu against Tengku Muhammad Saad Tengku Mansur case, the Malaysian Court of Appeal sees constructive trust as a relationship developed by equity in the interest of consigned. It does not depend on express or presumed intention. This shows that fairness might require court to intervene even if the parties did not create a trust with intention. H.I. Singh articles on the Api-Api constructive trust test says that Tay Chiu Fu case has helped in developing the perspective that constructive trust can be used as a remedial device to avoid unjust enrichment. This is fair when court apply constructive trust in wrongdoing cases where a fiduciary misuses property or receives property in breach of duty. It would be unfair to let that person to keep the benefit just because no express trust was created. Equity focuses on consign. There are situations where the defendant have acted fraudulently, dishonestly, or in breach of duty. This is when constructive trust can stop them from profiting from their wrongdoing. This shows the principle that equity will not let legal title to be used as a tool of fraud. This is shown in Bannister against Bannister. This case shows that without a written trust, equity may intervene where one party depends on legal title to defeat a prior understanding and cause unfairness. Takako Sakao against Ng Pek Yuan is an important Malaysian landmark case. The dispute involved a Japanese investor and Malaysian party in a restaurant business. The federal court recognized a constructive trust because there was a breach of fiduciary duty. The court also referred to the Paragon Finance principle. The court did not create a trust out of sympathy for the claimant. The court created constructive trust as there was fiduciary duty, unconscionability, and misuse of property. Thus, this makes the constructive trust fair because it looked at identifiable legal wrong rather than deciding on feeling of unfairness. A legal article published by Malaysian law firm Scream states that Takako Sakao is a landmark case that supports constructive trust principle in Malaysia. However, there is still risk if constructive trusts are used too freely. This will make property law less stable and will become an issue because property rights need to have clear rules. If a person holds legal title, then third parties should be able to depend on it. The commercial party may find it hard to know the ownership, security interests, and remedies when constructive trust is used too freely. Therefore, Malaysian courts must avoid treating unconscionability as a magic word. The court should give clear explanation on why the defendant's conscience is affected. There should be analysis to check whether there is fraud, breach of fiduciary duty, common intention, detrimental reliance, or unjust enrichment. Constructive trust may become unpredictable without analyzing this. This concern can be seen in Malaysian academic criticism of the broad remedial constructive trust approach. In Hang Wu Tang and Ying Kai Liu's article, they argue that Malaysian courts use unconscionability too commonly. This causes unprincipled and unpredictable legal development. However, their argument does not say constructive trusts are not useful and suggests that fairness needs methodology. For constructive trust to be fair, it must depend on clear explanation on principle and not just judicial instinct itself. Therefore, the difference between institutional and remedial constructive trust is important. Institutional constructive trust will automatically exist when legal facts meet the recognized equitable principles. Remedial constructive trust is used by the court as a remedy during judgment. The remedial model gives courts wider discretion. However, it can also cause uncertainty. Malaysian law seems more open to remedial constructive trust instead of traditional English law. But this openness must be used with care. The Federal Court and Court of Appeal need to make sure remedial constructive trusts are not used just because they sympathize the claimant. In my first argument, I mentioned courts are fair when they impose constructive trust without intention as long as they are responding to unconscionable conduct. In these cases, the lack of intention is not weakness, but this is exactly why constructive trust exists. Equity comes in because the defendant's legal ownership does not match the requirement of fairness and conscience. But the court must still give clear reason and explain the exact equitable reason for imposing the constructive trust. Next evaluation focus on how Malaysian courts use constructive trust. The focus is whether the courts have been fair. Therefore, fairness must be tested through Malaysian cases. There's a Malaysian landmark case, Luggage Distributor Sdn Bhd against Tan Ho Ting. The Court of Appeal agreed that there is constructive trust if the defendant's conduct has made it unfair for them to keep the benefit. This highlights that constructive trust is not based on express intention only, and equity can look at what the parties have done. There is a situation where one party takes property or money in a situation that is unfair to keep it absolutely. The court can impose a constructive trust. Hence, this has supports fairness. This is because the law looks over formal title and asks whether the conduct of defendant is affected. However, Malaysian court must still be cautious. A constructive trust should not be imposed just because one side suffered loss, because the loss itself is not sufficient. Let's say the defendant did not act unconscionably, fraudulently, or commit breach of duty. Then, a proprietary remedy may be unfair to the defendant and third parties. This is because constructive trust gives the claimant a proprietary interest and not just a personal claim for damages. This situation will prioritize the claimant ahead of unsecured creditors. Therefore, the fairness to the claimant need to be balanced against fairness to others. This issue becomes clearer in RHB Bank Berhad against Travel Sites Sdn Bhd. The federal court has accepted remedial constructive trust in Malaysian law. This was important because traditionally, English law prefer institutional constructive trust. The Malaysian approach is more flexible. One argument is that this is fair because court can choose a remedy that suits the case. However, on a different perspective, it is risky because a remedial constructive trust can create a proprietary interest only when the court gives judgment. This can affect certainty in commercial and creditor priority. Tang Hang-Wu and Liu Ying-kai also criticized RHB Bank against Travel Site for causing uncertainty. They also criticized the failure in clearly distinguish between institutional and remedial constructive trust. This is good criticism. It looks like remedial constructive trust would be desirable if fairness involved just justice between the two parties. However, equity have to be fair in the larger legal system. For banks, buyers, creditors, and liquidators, a set of rules that are predictable is needed. The grant of constructive trust may turn property law into a fiction. Thus, fairness requires legal disciplines. What is also relevant is a federal court case which has become a classic that is referred as Api-Api Constructive Trust Test in Perbadanan Kemajuan Pertanian Selangor against JW Properties Sdn Bhd. H.I. Singh, Safinas Muhammad Hussain, and Nur Khalidah Dahlan described the federal court's effort to develop a three-pronged test for constructive trust. Its importance lies in an attempt to shift Malaysian law from arbitrary discretion towards clearer principles. The Api-Api test is helpful because it brings the unconscionability to the surface of known facts. The court should look to see if a relationship, dealing, reliance, breach of duty, fraud, or other conduct made retention on the part of the court or the parties for the property unconscionable. This is fair, as otherwise constructive trust might become a means of general remedy for disappointment. It also protects Malaysian land and commercial law. The land context is sensitive due to the Torrens syndrome as outlined in the National Land Code. Registered title was designed to give certainty. Constructive trust on land may be detrimental to the operation of the older engines of registration if they are too easily enforceable. Malaysian courts, however, have accepted that indivisibility of title does not completely exclude equity. If in appropriate circumstances, a registered proprietor has been in possession of land under circumstances which make it unconscionable to claim full beneficial ownership, then he or she may have it held on constructive trust. This is reasonable if the title is derived or maintained by fraud, breach of duty, or through clear detrimental reliance. It would certainly be unfair to jump over these statutory land rules without appropriate equitable reasons. This balance shall be reflected in the context of courts asking themselves whether the defendant's consign will be compromised. In Takako Sakawa against Ng Pek Yuan, the federal court found a constructive trust as the facts related to a breach of fiduciary obligation and duty. The claimant had invested in property and business arrangement, and the defendant's conduct make it inequitable to deny her beneficial interest. This court ruled fairly when it gave some reason that a real beneficial interest must not be defeated by a legal title. In Takako Sakawa against Ng Pek Yuan and Anor, the federal court considered the issue a constructive trust created by its ruling in accordance with an alleged breach of fiduciary duty and allowed a claim for beneficial share. Generally, in fiduciary cases, it's the same reasoning. A fiduciary must be loyal and relationship of trust and confidence, such as that between a trustee and another person, an agent and his principal, a company director and the company, a solicitor and his client, or another. If a fiduciary gets property or profit by breaching their duty, a constructive trust is fair because it stops them from keeping the benefit from their wrongdoing. The court is not creating a new trust. It is instilling loyalty or conscience. This corresponds with the English case of Kitch and Sanford, in which the mere fact that a trustee obtained a lease renewal through a fiduciary position did not give him the right to keep it, and also with Boardman against Phipps, in which circumstances fiduciary would still be obliged to account for any money profits they made even if they acted with good faith on behalf of the trust. These cases demonstrate that constructive trust and other equitable remedies are straight but may be fair because conflict of interest are not permitted in the case of fiduciary relationships. However, this strict fiduciary liability also gave rise to issue of fairness. In Boardman and Phipps, the fiduciaries acted on an instance of good faith and conducting the trust estates affair, but they still had to give up the profit they made. This can sound a bit on the strict side, but equity is flexible through an allowance for skills and effort. Therefore, constructive trust involves more than punishment of the defendant and is not only one suffering from it. It allows no unauthorized profit, recognizes the genuine contribution. This is a balance that should be adopted by Malaysian courts. Other cases include Abdul Razak Junda Khan, an organization, against Mustafa Mohamad against an organization. The court referred to Luggage Distributors case. The intention of the parties and the facts was so clear that the Court of Appeal that it was inequitable for the respondent to claim rights to the sum of certain amount. This demonstrates that Malaysian court has been willing to apply constructive trust to prevent one party from being able to frustrate the intent of an arrangement. This case has also revealed that intent is not wholly irrelevant. The question is, no trust were intended by the parties. This result in no formal express trust was intended. However, there is still a question about whether the conduct, expectation, and arrangement of the party could have been important. Unlike a constructive trust, there's no apparent intention, but there's a question as to what is the fairness of not granting an interest to someone if the defendant's action make it unfair. In this respect, intention is substituted by for reliance, equitable obligation, and conscience. The second argument here is that Malaysian courts are generally fair when awarding constructive trust on the basis of fraud, fiduciary breach, unconscionability, detrimental reliance, and/or unjust enrichment. However, if constructive trust were used as a remedial term without specific reasoning as to why a proprietary remedy is appropriate, court can be unfair. The last part will review if constructive trusts are unfair when there's no intention. I don't think it does in my opinion. Constructive trust is not for the purpose of enforcing intention like express trust. It aims to provide protection for equitable interest in cases where the legal title would create injustice and to prevent unconscionable acts. Therefore, the principle of English are still valid. The English Court of Appeal in case of Paragon Finance PLC against DB treated constructive trust as arising by operation of law where it would be unconscionable for the legal owner to assert full beneficial ownership. This influence has also been embraced by Malaysian courts, particularly in Takako Sakau against Ng Peng Yuan, where the federal court recognized a constructive trust in favor of the claimant and treated the defendant's conduct as equitable fraud. In this case, the appellant was entitled to a one-half interest as a constructive trustee for a trust and his interest could be traced. It demonstrates all that constructive trust is fair as it prevents the use of legal ownership from being used in an unfair manner. If court would never create constructive trust again because there was no intention to create a trust, the wrongdoer might have a leg to stand on based on the formal title. This would undermine the reason for equity. Thus, constructive trust is used to support fairness, whereby legal rights are not exercised to one's consigned. But not all such situations are fair. They are only fair when applied in an explicit reasoned legal manner. This is where trouble set in with the Malaysian law. According to Tang Hang Wu and Liu Ying-kai, Malaysian court depend too heavily on the application of broad terms such as unconscionable and the remedial constructive trust that had result in the lack of principle and predictability in cases introduced into the jurisdiction. This criticism matters because it's not only about the claimant's fairness, it also covers the defendant, third party, creditor, purchaser, and certainty of the property law. Malaysian case such as RHB Bank Berhad against Travel Sites Sdn Bhd is important because federal court admitted the existence of remedial constructive trust in Malaysian law. As discussed in Chu E. Kong's article, RHB Bank case is described as a landmark but should also be noted that it has raised issue over proprietary restitution and remedial constructive trust. Perhaps a more harsh criticism of the reasoning in RHB Bank case is found in Wax Chun's article, which point out that the court described the trust to be a remedial trust when the reasoning seemed to be closer to being an institutional constructive trust. This is the reason why remedial constructive trust can prove challenging as it can only be helpful to the claimant but could also affect creditor priority. If a claimant obtains a proprietary remedy, they can have a better claim than the unsecured creditors. Therefore, the court has to provide a reason for why the proprietary remedy is appropriate rather than damages, account for profits, restitutional, or compensation. If this is not explained, the outcome could seem like it's fair but not a legal one. However, the RPRP test decision is significant because the federal court tried to give constructive trust reasoning more structure. The RPRP Constructive Trust Test article explained that the court created a three-part test and said constructive trust should be based on clear principles, not just the judge's personal choice. This is a good sign as it draws a balance between flexibility and certainty. A similar trend can also be seen from the Malaysian land context in this regard. The Tory system gives an extreme degree of protection to the legal title, but equity still applies where a registered proprietor's conduct make it unconscionable to deny another person's interest. This is fair where there's a fraud or breach of duty or any detrimental reliance or a clear equitable obligation. It would be unfair if the constructive trust granted the benefit without observing necessary statutory requirement or weakened registered title without strong justification. Therefore, Malaysian court should treat constructive trust as an exceptional equitable response and not on a broadly based power to alter ownership. The most fair solution is based on the principal solution of Malaysia that is known as 4 safeguards. First, it is important to find out what type or classification of the law is involved. What is the nature of the case, such as a claim arising from a fiduciary breach, or a claim under common intention, or fraud or mistaken transfer, or vendor-purchaser claim, or unjust enrichment, or proprietary as to whole. This will ensure that unconscionability isn't used as an empty label. Second, courts should ensure that there is an adequate explanation of the necessity for constructive trust. If personal remedies are enough, constructive trust may be excessive. A proprietary remedy should only be sought when the claimant has a genuine equitable interest or when it is not equitable for the defendant to retain the specific property. Third, the third-party effect should be taken into account by the court, particularly in insolvency, banking, and land conflicts. Innocent creditor or purchaser should not be unfairly harmed just to achieve fairness for one claimant. Fourth, court must align Malaysian law with the English law but adapt the law with care. Malaysia can create its own fair doctrine, but it shouldn't use English cases selectively. While cases like Paragon Finance and West Dutch Letters Bank against Illingston's LVC, Kitch and Sanford, Bonland and Fitz, Bannister against Bannister, and Repolypack provide useful foundations, Malaysian court must apply them according to Malaysian statutes, land law, and local policy. Therefore, courts have been fair in imposing constructive trust even when no trust was intended, but only where unconscionability is supported by clear facts and recognized equitable principles. The principles of fairness are aimed to prevent fraud, fiduciary disloyalty, unjust enrichment, or abuse of legal title. Unfairness happens when constructive trust is used too widely, especially when the court uses it as a shortcut without explaining why a proprietary remedy is necessary. Therefore, courts have been fair in imposing constructive trust even when no trust was intended, but only when unconscionability is supported by clear facts and recognized equitable principles. The principles of fairness are aimed to prevent fraud, fiduciary disloyalty, unjust enrichment, or abuse of legal title. Unfairness happens when constructive trust is used too widely, especially when the court uses it as a shortcut without explaining why a proprietary remedy is necessary. For this reason, the strongest position is balance, where constructive trust is fair not because judges have unlimited discretion, but because equity have discipline consigns. In Malaysia, the best way is avoid from rejecting constructive trust. Instead, it would be better to refine that. Constructive trust should be applied by courts when legal ownership would cause unfairness. However, court must explain their reason clearly, use proper legal categories, and consider how it will affect third parties. To summarize, the court can be fair in imposing constructive trust even without intention because constructive trust is based on consigns, not express intention. But there must be principal limits on this fairness. If there was no limit, equity would become erratic. Given those limitations, constructive trust still can be an important mechanism to prevent legal title from becoming an instrument of injustice. That's all from me. Thank you.